Be ready. Start. In construing any facts to find whether the prosecution has complied with the mandate of any provision which is mandatory, one has to examine it with a pragmatic approach. The law under the aforesaid act being stringent to the persons involved in the field of illicit drug traffic and drug abuse, the legislature time and again has made some of its provisions obligatory for the prosecution to comply with, which the courts have interpreted it to be mandatory. This is in order to balance the stringency for an accused by casting an obligation on the prosecution for its strict compliance. The stringency is because of the type of crime involved under it, so that no such person escapes from the clutches of the law. The court, however, while construing such provisions strictly, should not interpret them so literally so as to render their compliance impossible. However, before drawing such an inference, it should be examined with caution and circumspection. In other words, if in a case the following of a mandate strictly results in delay in trapping an accused, which may lead the accused to escape, then the prosecution case should not be thrown out. Apparently, and in fact, admittedly, there is no compliance with the provisions of subsections 1 and 2 of section 42 of the Act, and they are mandatory and not directory. Once there is non-compliance of these mandatory provisions, the appellant is entitled to acquittal. The High Court, while relying upon the judgment of this court in Baldev Singh and rejecting the theory of substantial compliance which had been suggested in Joseph Fernandez, found that the intimation did not satisfy the provisions of Section 50 of the Act. The court reasoned that the expression duly used in Section 50 of the Act connotes not substantial but exact and definite compliance. Wide Exhibit PW 6/A, the appellant was informed that a gazetted officer or a magistrate could be arranged for taking his search if he so required. This intimation could not be treated as communicating to the appellant that he had a right under law to be searched before the said authorities. As the recovery itself was illegal, the conviction and sentence has to be set aside. It is a settled canon or criminal jurisprudence that when a safeguard or a right is provided favoring the accused, compliance therewith should be strictly construed. The theory of substantial compliance would not be applicable to such situations, particularly where the punishment provided is very harsh and is likely to cause serious prejudice against the suspect. The safeguard cannot be treated as a formality, but it must be construed in its proper perspective. Compliance therewith must be ensured. Law has provided a right to the accused and makes it obligatory upon the officer concerned to make the suspect aware of such right. The officer had prior information of the raid, thus he was expected to be prepared for carrying out his duties of investigation in accordance with the provisions of Section 50 of the Act. While discharging the onus of Section 50 of the Act, the prosecution has to establish that information regarding the existence of such a right had been given to the suspect. If such information is complete and ambiguous, then it cannot be construed to satisfy the requirements of Section 50 of the Act. Non-compliance with the provisions of Section 50 of the Act would cause prejudice to the accused and therefore amount to the denial of a fair trial. When there is total and definite non-compliance of such statutory provisions, the question of prejudice loses its significance. It will per se amount to prejudice. These are indefeasible protective rights vested in a suspect and are incapable of being shadowed on the strength of substantial compliance. The purpose of these provisions is to provide due protection to a suspect against false implication and ensure that these provisions are strictly complied with to further the legislative mandate of fair investigation and trial. It will be opposed to the very essence of criminal jurisprudence if, upon apparent and admitted non-compliance of these provisions in their entirety, the court has to examine the elements of prejudice. The element of prejudice is of some significance where provisions are directory or are of the nature admitting substantial compliance. Where the duty is absolute, the element of prejudice would be of least relevancy. Absolute duty coupled with strict compliance would rule out the element of prejudice where there is total non compliance of the provision. The prosecution has not been able to establish this aspect of the case beyond reasonable doubt. We do not consider it necessary to deal with the other contentions, including the plea taken with regard to compliance of Section 50 of the Act. Thank you.